Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content, and today may be the day I earn your subscription. For today's story, we are talking about potential charges against the parents and others involved in the recent Michigan school shooting. So as I'm sure many of you are aware, there was a school shooting recently in Michigan. There were 4 deaths as a result of this school shooting, and the prosecutor has obviously charged the child involved with 4 counts of first-degree murder, along with other charges, including terrorism and other things. But what's interesting for today's analysis is not his fate, which, you know, we can already know the end of that page. We already know where the end of that's going, right? So we can just skip right ahead on that one. But more interestingly, to his parents and what potential liability they might have, because the prosecutors in Michigan have, perhaps surprisingly, charged the parents, both of them, with 4 counts of first degree, or apologize, just 4 counts of involuntary manslaughter. I don't think it's a degree thing in Michigan. Anyway, so the 4 counts of involuntary manslaughter, each count of which can have a maximum of up to 15 years. So hypothetically, if they're all served consecutively, then you're talking about 60 years in jail. Although, of course, they're part of one continuous criminal act. So the standard rule would be to serve concurrently, but, you know, that can be modified by a whole bunch of things. Either way, we're talking about some fairly serious charges. And even if it's the one charge, even if it is the one, each one would be aggravated by the other 3. So whatever the sentencing guidelines or otherwise, you would aggravate them by the other 3. So you're looking at a 15-year minimum as a real practical impact on this one. So that's basically alongside of that. But the thing is, can we charge the parents? What is our theory of the crime? Well, to understand what our theory of the crime is, we need to ask the prosecutor themselves, who at least in the press statement has given their initial theory of the crime. Now, I think it is obviously worth mentioning, of course, that this is not a formal legal presentation. This is not a formal indictment from a grand jury. This is not a formal information from the prosecutor's office. This is just a statement of the facts. So there can and may be modifications of this by the time it becomes an official legal document, but at least it gives us a nice heads up of where we're heading. So we're going to read this. We're just going to read the transcript of this. So here's a transcript of the statement she made. While the shooter was the one who entered the high school and pulled the trigger, there are other individuals who contributed to the events on November the 30th, and it's my intention to hold them accountable as well. It's imperative we prevent this from happening again. No other parent or community should have to live through this nightmare. I have shared previously, and I'll reiterate today, that gun ownership is a right. And with that right comes great responsibility. Based on the information and evidence I received, today I'm announcing charges against the shooter's parents, Jennifer and James Crumbly. The charges are as follows. James Crumbly is charged with 4 counts of involuntary manslaughter. Jennifer Crumbly is also charged with 4 counts of involuntary manslaughter. I will now publish the details that led to this decision and have already been made public. Presumably, she might be referring to official court proceedings, so this may very, in fact, mirror things that have already been filed before a court. The investigation into the school shooting incident at Oxford High School, which occurred on November the 30th, 2021, has revealed that James Crumbly purchased the Sig Sauer 9mm model SP 2022 from Acme Shooting Goods in Oxford, Michigan, on November the 26th of 2021, so just 4 days prior. A store employee confirms that Ethan Crumbly was present with James at the time of the purchase, so father and son together. Per statute, James Crumbly completed the ATF form required for this. On or about November the 26th, Ethan Crumbly's social media posts revealed photos of a semi-automatic handgun, along with the caption, "Just got my new beauty today," including an emoji with hearts. Sig Sauer 9mm. Any questions I will answer. Subsequent to the purchase of the weapon, one of Jennifer Crumbly's social media posts on or about November 27th, 2021 read, Mom and Sunday testing out his new Christmas present. The day before the shooting, a teacher at the Oxford High School observed Ethan Crumbly searching ammunition on his cell phone. during class and reported the same to school officials. Day before, school officials observed him searching for ammunition on his cell phone. Report it. Jennifer Crumbly was contacted via voicemail by school personnel regarding the son's inappropriate internet search. School personnel indicate that they followed that voicemail up with an email but received no response from either parent. Thereafter, Jennifer Crumbly exchanged text messages about the incident with her son on that day, stating, "Lol, I'm not mad at you. You have to learn not how to get caught." So, I mean, obviously that can be read fairly damningly, depending on your frame. And I'm sure it will be, it will be made damning by the prosecutor and emphasized by the prosecutor. Why didn't you have a greater concern about that? But, her son is searching for ammunition. The school calls her and she just says, "Lol, not mad, just try harder not to get caught." So, okay. I mean, that could go to a mental state element, I suppose. So on November the 30th of 2021, the morning of the shooting, the next day, Ethan Crumbly's teacher came upon a note on Ethan's desk, which alarmed her to the point she took a picture of it on her cell phone. The note contained the following: a drawing of a semi-automatic handgun pointed at the words, "The thoughts won't stop, help me." To another section of the note was drawing of a bullet with the following words above the bullet: "Blood everywhere." Between the drawing of the gun and the bullet is a drawing of a person who appears to have been shot twice and bleeding. Below that figure is a drawing of a laughing emoji. Further down the drawing are the words, "My life is useless." And to the right of those words is, "The world is dead." Well, this strikes me as a note of concern, my friends. This strikes me as a note of concern. This is a lot. It could obviously be fantasy, it could be imagination, but it's definitely worth enough for an inquiry, one would think. But perhaps most notably to our inquiry, the teacher observed it, took a picture of it on her cell phone. All right, let's read some more. As a result, James and Jennifer Crumbly were immediately summoned to the school. A school counselor, detail that will matter, came to the classroom and removed the shooter, or at this point non-shooter because it hadn't happened yet, and brought him to the office with his backpack. Counselor obtained the drawing, but the shooter had already altered it. But remember, there was a picture taken, so they know exactly what it looks like. The drawing of the gun and the bloody figure were scratched out along with the words, "Help me and my life is useless. The world is dead and blood everywhere." Those were all altered by him. At the meeting, James and Jennifer Crumbly were shown the drawing and presumably the picture on the phone, which, and were advised that they were required to get their son into counseling within 48 hours. Not the worst advice, to be quite honest. Both James and Jennifer Crumbly failed to ask their son if he had a gun with him. Guess who else failed to ask, incidentally? Or where the gun was located, and failed to inspect his backpack for the presence of the gun, which he had with him. Who else failed to ask? James and Jennifer Crumbly resisted the idea of their son leaving the school at that time. Instead, James and Jennifer Crumbly left the high school without their son. He was returned to the classroom. Please take note also that the teacher was there. The teacher is there. The school counselor is there. And presumably the principal is there, although it doesn't say it explicitly. In addition to the teachers. So 5 adults in this room and the student. So this is going to become important in our legal analysis later. When news of the school shooter at Oxford High School had been made public, Jennifer Crumbly texted to her son at 1:22 p.m., "Ethan, don't do it." At 1:37 p.m., James Crumbly called 911, reporting that a gun was missing from his house, and he believed his son may be the shooter. Apparently, as soon as he heard about the shooting, he drove back to his house to look for the gun, couldn't find it, and then called 911 at that point. Further investigation reveals that the Sig Sauer 9mm handgun purchased by James Crumbly was stored unlocked in a drawer in James and Jennifer's bedroom. So it was in their bedroom, but unlocked. The gun recovered from the shooter at the school after the shooting was the same gun that was purchased by his father, James Crumbly, on November the 26th, 2021, in the presence of his son. I want to be really clear that these charges are intended to hold the individuals who contributed to this tragedy accountable, and also send the message that gun owners have a responsibility. When they fail to uphold that responsibility, there are serious and criminal consequences. As we work together to honor the lives lost and all those impacted by the evil events this week, justice for the victims and their families is at the forefront of today's announcement. We need to do better in this country. We need to say enough is enough. All right. So that's everything the prosecutor has to offer. It's everything we have to offer. So let me summarize. Summarize the statement of facts as we now know them, or at least up to this point we know them, because, again, as investigations change, we may gain more evidence. But this is what we have so far. 4 days before the shooting, his father and the son went to a sporting goods store and bought this cig. The day before the shooting, so that'd be 3 days after they purchased it, he was caught searching for ammunition. The school made a note of this, called his parents, sent him an email, no response. But the school knows. The day of the shooting, they see him with this drawing, which is fairly graphic and suggestive. And they bring him and his backpack, presumably to the principal's office. We know the school principal is there. We know the teacher is there. We know the two parents are there. We know he's there. And some conversation ensues. The conversation apparently is of the nature that, we'd like you to take your son home. They say, no, we're disinclined to do that. We don't want to do that. We're not going to do that. Okay. As the prosecutor points out, they didn't search the bag. Who else didn't search the bag? Yeah. That would be the school counselor, the teacher, the principal. Do the individuals have authority to search the backpack without a warrant? Yes. Yes, they do. Yes, they do. They can do that, not for least of reasons that they have probable cause, but even if they didn't, the standards at school, as I'm sure you can appreciate, are a bit different than apply in the normal world. There's any number of case law. So the principal could have been like, I'm going to open it. And as I was talking to Stephanie before this stream, a lot of kids will say, well, you can't do that. My parents said you can't. You can't do that without a police officer. Call the police. But you can. So well, first of all, you could call the police, obviously. Second of all, you can just ignore them and open the backpack because it's fully legal. There's case law on point. It's not exactly a controversial proposition. So the fact the school officials didn't insist on checking it, there are some issues there, it seems to my mind. Search his locker as well. Exactly the same thing. Exactly the same thing. All right. And a school police officer, assuming they had one, which I don't know if they did or not. They might have. Some people are saying they failed to call the resource officer, so there might have been a police officer on scene, which is even more damning. A lot of schools have a police officer on scene. They're called usually a school resource officer. So it didn't even call them in, which is also damning for the school and a whole bunch of other things. All right. So first of all, let's discuss what the crime of involuntary manslaughter is. And to do this, we'll do it through the jury instructions. So here are the jury instructions. The defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant, in this case, that would be each of the parents separately. First, that the defendant caused the death of, that is, whomever, died as a result of whatever they did or failed to do. Not searching the backpack, giving him the gun, buying him the gun, whatever. Second, in doing that act that caused the death, the defendant acted in a grossly negligent manner. Grossly negligent manner. And third, the defendant caused the death without lawful excuse or justification. So what is a grossly negligent manner? Well, fortunately, Michigan has you covered there as well. They have that defined as well. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, the defendant knew of the danger to another. That is, he or she knew there was a situation that required him or her to take ordinary care to avoid injuring another. Second, the defendant could have avoided injury by using this ordinary care. And third, the defendant failed to use ordinary care to prevent injury to another when, to a reasonable person, it must have been apparent the result was likely to be serious injury. All right, so here are my reasons Here are my reasons for being kind of skeptical on this charge, right? Now, we don't have enough information to fully clear the parents at this point, because this school shooting, as I mentioned, happened a mere 4 days after the purchase of the firearm. The timing is more than a little bit suspicious. It might be suggestive that the parents had information that is presently unknown to us about their child potentially being a danger to himself or others. Probably didn't wake up 4 days later and say, you know what, I'm going to be a school shooter today. That's probably not a thing that happened. Much more likely is there were indications to them. We don't know if this for a fact, but let's use our thinking brains and think about it for a second. Much more likely is that they had information that might suggest to us, or suggest to them, or suggest to a reasonable person that their son might be a danger, that buying him this handgun might not be a great idea. All right? So there's that. Maybe there is negligence in buying him the gun because, they, as being parents, might know about, and you better believe that by the time this comes to trial, the prosecutor's going to know everything there is to know about every time the parents have been warned. How many incidents of bullying has he ever been involved in? How many times have the parents been warned? How many times has he ever hit someone? How many times has he ever stolen something from someone? How many times has he ever behaved in a belligerent way? How many times were the parents warned? Whether at school or otherwise. Forget school for a second. How about, I don't know, other activities? How many times did the church warn him, or people at church? How many times at soccer practice, or people at soccer practice? Insert further things here. How many times did that occur? You better believe they're going to know the answers to all those questions to try to make it look like this was reckless, grossly negligent from the start. We obviously don't know that yet, but, it's probably coming down the pipe because we're not dumb. So there's that problem. But here's another thing too. So there's that, but here's the problem, at least in my view. The intervention by the school in bringing him to the school's office is, to my mind, an intervening cause, or at least potentially, right? Let's not overstate this. Let's not overstate this and say this is a slam dunk. But it raises a possibility, and a fairly prominent one in my mind, although by no means conclusive, but I definitely argued if as I defense, that the school is an intervening cause. If the school is an intervening cause, that means it breaks the causal chain. It's a break in the causal chain. If they're intervening cause, then they're the cause, not the parents anymore. So even if they were negligent in buying the firearm, even if they were negligent in keeping it unlocked, right? If you show the school is a legally intervening cause, it breaks the causation chain. And now suddenly we're only starting from that point forward. No, we're not going any further back than that. That's the nature of an intervening cause. Why do I say the school is potentially an intervening cause? Well, because the school had all this actual knowledge. They had actual knowledge. They knew about the purchasing, or knew about the ammo. And perhaps even more importantly, they knew about the photograph. They knew about the picture. They had the picture in its, in its modified state, but they had a picture of the original. They knew exactly what it looked like, and I'm sure, and as testimony will show, I have no doubt, that this original picture was shown to them and the school counselor and everyone else. Right? Shown to everyone else. Everyone had knowledge of this. And the backpack was in the room. So the question is, well, they want to say, okay, the parents were negligent, grossly negligent, in fact, for not looking in the backpack. Here's the problem. You, the school officials, knew everything they knew, and if anything, you knew more than they knew. At least up to that, at least as it relates to the things that we're talking about, like the photographs, the school, those things. You know more. You know more than they do. So you have actual knowledge of all those things. And if it's grossly negligent, in other words, if you're consciously disregarding a known risk, basically reckless, if you're consciously disregarding a known risk with a devil-may-care attitude, in the face of information that should bring a a person to stall. You know who else is responsible here? The teacher, the principal, and perhaps even most notably of all, the school counselor. The school counselor, who, you know, is even in a better position to know about whether or not this student is a threat because they're a professional of some kind in the field, right? And the school says, take him home, and they say no. But they don't say, well, you have to. We're kicking him out. We're calling the police. He can't go back to class. You know, they don't say any of those things. We're going to just sit him here and watch him for the rest of the day. They don't say any of those things. They don't say any of those things. They say, okay, go back to class. So here's the question for the prosecutor to answer. If it was so obvious, if it was so notable that this kid was a ticking time bomb ready to explode, how did the principal, how did the school teacher, and most notably, how did the school counselor not come to that conclusion? How did they not search his bag? If they have a school resource officer on site, which seems to be the overall conclusion here, why did they not call the school resource officer if they were that concerned about this guy and this imminently dangerous situation that is now developing? You know, it looks like the school isn't even taking it that seriously. I mean, they're concerned, obviously. They said that apparently you have 48 hours to get them, you know, psychology. They said you only have 48 hours to get them psych evaluation, I think, at that meeting. Or maybe it was the meeting before. No, it was that meeting. It must have been. But they didn't, you know, prevent him from going to class or prevent him from taking his backpack or look in the backpack or any or all of those things. Any or all of those things. So I'm having a very, very difficult time in my mind getting to liability, although, you know, maybe we can get there. So this is not a, you know, at least at the moment, because we don't have all the information, right? But I'm having a difficult time at the moment. So further information could come in that would change the analysis. But at least where we're sitting right now, I'm having a somewhat difficult time seeing how we get to gross negligence by the parents without also getting to gross negligence by the teacher, the principal, and or the school counselor, who are in as good, if not a better position, particularly based as it might be on professional training, right? Because presumably they have degrees in education, which, you know, talks about that presumably the school counselor has some sort of psychology degrees or something, like, and they're in a better position, if anything, and they're like, go off to school. So how can they be? So you know, if I'm the defense attorney for these guys, given what I know, and assuming that they don't charge the school people with it, first of all, I'm calling all three of those people on the stand on my defense side, right? And watch them plead the fifth, which would be hilarious, you know. And I'm gonna definitely, it won't be obviously the dominant part of my argument. It won't be the major thrust of my argument, but you better damn believe that it's gonna be part of my argument as the defense lawyer. Like, how can these guys be negligent when these guys aren't on trial? The state obviously thinks this guy was a ticking time bomb. Where are the school officials who were in a better position? No, this is a joke. This is a farce. You shouldn't take that seriously, right? Obviously, I massage it a little bit more than that, but that's, you know, kind of the thrust. It's like, where's the real accountability of this? And if they do wind up charging the school officials and put them on trial all at the same time, which would be hilarious, right? Because it would be part of the same contemporaneous series of events. So at this theoretical trial that might occur in the future, you could have both parents and the principal and the teacher and the psychologist, potentially five defendants sitting at this future table sometime. That might be interesting and fun. But we're a long, long way away from there, my friends. A long, long way. And the fact that we haven't charged any of the school officials yet is a little bit suspicious, at least to my mind. All right, so that's what I think so far. So far, I am somewhat skeptical. So far, I'm somewhat skeptical against parents of the parents because the parents, only assuming nothing else, which, you know, yeah, but we don't know that. So assuming nothing else, all the parents know about was one search for ammo, which why would that necessarily freak them out by itself? And then when they're brought into school, they see the picture and then they see the school officials not freaking out about it. So why do they freak out about it? And one of the suggestions has been, well, why did the mom text her son, saying don't do it once the school shooting started? Surely she knew something, right? Why would she send that text message to her son saying don't do it if she didn't think that he was a danger to himself? And the answer to that, as the defense lawyer, without even breaking a sweat, is because you just told her earlier that exact same day about the pictures with the guns and the bullets and the blood and all the slogans, right? You just told her. She was just there. You gave her that information, right? You gave her that information. And now, and she is now at home hearing about a school shooting and maybe puts two and two together, right? Oh, geez, no, maybe he really did mean it. Maybe he really is a threat. Don't do it. Because now she has reason to think that. Is it because she has a guilty mind from the things that occurred earlier that she thinks her son is a blatant threat? Or is it because the school just told her like 5 seconds ago her son is a blatant threat, and maybe that's why she's reaching those conclusions without even breaking a sweat? That's how I get that away as a defense lawyer. It's not even a problem. Super easy, barely an inconvenience. Okay, so we have a whole lot of room to go. We have a whole lot of room to go, baby. We are nowhere near the end of this thing. All right, but we have more information to bring to your guys' attention. In this wonderful article that's raising some other issues that we should talk about. Okay, so here's a fun possibility. It appears, my friends, that the ATF, the feds, are now involved in this. It appears the ATF is now involved in this party. You might want to know to yourself, how could the ATF be involved in this? Well, here's the really easy answer. It was because they purchased the gun for their son. It's a federal crime to purchase a handgun in your name and give the handgun to someone else. It's a straw purchase. They're going for straw purchase, people, because it wasn't his gun, right? It wasn't the father's gun. It was his gun, remember? Because they said things like, oh, this is mom and son together for this Christmas gift, and the son was there at the purchase, so the father wasn't buying it for himself with an idea that his son will use it under his supervision. No. His father was actually buying it for his son to be his gun as part of his birthday present. So we're now thinking straw purchase because of this slightly loose language from some random social media posts. How super exciting. So the damn ATF is now involved in this because straw purchase. Also, because of the Gun Violence Protection Act, they're thinking about maybe bringing a charge against it for being in a school zone. So, all that good shit. Federal prosecutors are investigating to determine if federal laws were violated. Investigators determined that James Crumbley purchased the name. It was clear from social media it was bought for him. Remember all those very, very damning social media posts we read earlier about how mom and son were out together for an early Christmas gift? Yeah. In this case, the father claims he bought the handgun, but public comments that he got it for his son. The son is not 21 years old. It's a handgun. If it's a rifle, the person you're giving it to has to be at least 18. This is how dumb it's getting over here, people. This is how dumb it's getting over here. Because son was with them as they were purchasing the gun. It's not like, hey, what kind of gun might you be interested in getting familiar with? Oh, I'd be interested in that one. Okay, I'll buy it for you and we can use it together. Okay, son. Or because of these slightly sloppy social media posts. It's not that the father bought it for himself in his name and is thinking his son will use it from time to time. No. It's the father actually bought it for his son as a straw purchase. No. Good luck on selling that one. but I'm not seeing that really. The Michigan Attorney General is in on the picture, and it's confirmed that office will look into school laws we're violating by failing to report a possible threat. So there's that too. There's that too. Right? What else? What else are the teacher, the principal, and the school therapist? What else are they other than a teacher, a principal, and a school therapist? And for those of you who don't know the answer, or those of you who are not from the United States, the answer to this question is they're a mandatory reporter. What does that mean, mandatory reporter? I'm so glad you asked. By statute, certain people are obligated by law to report things to the police. Right? So if just a normal person, if just your ordinary, average, normal person comes into information by some reason, they don't have an obligation to report it to the police, right? No affirmative duty. So if I'm just passing you on the street and I see you, playing with guns or something, I can just keep walking and no harm to me, ma'am. But if I'm a teacher, if I'm a principal, if I'm a school therapist, and I'm acting within the scope of those roles as I am, and I have this and I don't report it, in addition to my potential manslaughter charges, violation of mandatory reporters. So we're looking into that too. Okay, so now there's this issue about whether or not the parents were fleeing, to which an attorney says no. So the parents were found apparently in a warehouse for the artist. So apparently in an attempt to literally prosecute all the people, to potentially prosecute all the people, the parents were found in a warehouse that is owned by this artist. So what can we potentially charge the artist with? How about accessory after the fact? How about aiding and abetting? A fugitive from justice? Okay. Okay. So apparently they had some prior relationship, which, whatever. And the artist says that they didn't know that they're wanted by the police, which, is kind of a critical element to the whole aiding, abetting, and accessory. You kind of have to know that. And then a legal analysis has said one of the interesting questions is going to be what evidence did they have that this guy knew the two were wanted? So can you get to any evidence? Now, these guys they wanted him to talk to the police, and like a good, sane person, he talked to them with an attorney, which, thank God for that. And here's what the police said. Mr. Sayarka, the artist, with his attorney, met with officials today at the Oakland County Sheriff's Office to assist in the investigation. The artist fully cooperated and answered all of law enforcement's questions. The artist did not assist the Crumbleys in evading law enforcement, did not know there was a warrant for their arrest, and did not know they were at his art studio at the time of the arrest. He's not been charged with any crime and will continue to assist. So far, nothing against the artist, but, they're out for blood. So, I wouldn't necessarily bank on that. But that's where we're sitting right now. So all those things. And yeah. Cody Sam says, aren't they school found officials bound by local apprentice? It's not exactly. Local apprentice gives them the ability to do stuff, but I don't think it quite works as a doctrine in this context, but it doesn't really matter. In that it really, so it doesn't really matter, but it was a nice question. You better look at Michigan law. It was a legal purchase, guys. Did I say it was illegal? Did I ever say, my friends? Someone said you better look at Michigan law. It wasn't a straw purchase, my friends. Did I ever say it was a straw purchase? Did I ever say it was a straw purchase? No, I did not. I said the ATF was looking at the first straw purchase. They're the ones who are thinking straw purchase. And when I was saying it's a straw purchase, it was a straw purchase. If you couldn't tell that I was being blatantly sarcastic, I don't know what to tell you, man. It's not something I think. It's just something the ATF. If there weren't enough signals, during the entire segment when I was talking about the ATF, if there weren't enough context clues to let you know that I thought the entire thing was ridiculous and absurd from start to end, let me assure you, I thought it was absurd. I wasn't claiming anything. I was mocking the shit out of the ATF. That's for damn sure. Yeah. So, let's take a look at some of your super chats. $5 from Scott Ashford. Thank you for covering the various Supreme Court cases. I've enjoyed your analysis. You are most welcome. $2 from Q Revere. I call BS on the parents having a stay about going home. $2 from Clumsy Clairvoyance. Why isn't the school being charged? Politics, duh. $5 from David Powell. Thank you. $5 from Daniel Turner. I bet that information comes out of the kid's history, and the backpack will become secondary to the initial gun purchase for disturbed kids. I mean, that's definitely where the state has to go. And it's hard to believe they won't be able to get there in some way. They'll find something. $2 for Super Mario Subpoena. So charges for the parents for cover your ass for motive might very well be indeed. And okay. Let's take a look at some questions that you guys have been asking. Someone asked about failure to report. Do we know if the gun was locked up? It appears no. $20 from Dr. Spoon. Does bring up the question, if school officials suspected physical child abuse, they'll report it. With this, it's fine. Who here remembers voluntary suspected drug searches? Yeah, absolutely. Thank you for the super chat, Dr. Spoon. It's very appreciated. Townsend said, like many schools, Oxford High School does have a police officer patrolling its halls. So even worse. They have a police officer on site. Even worse. How much of a threat can he possibly be, right? The defense case begins to write itself. In your head. Or at least it does in my head. But that's, it does in my head. I'm like, oh, you had a school resource officer on site. You didn't call. Okay. Oh, you had this painting. You had this picture with all these disturbing things. And you knew about the ammo searches. That didn't disturb you enough. You weren't concerned. You sent him back to class without searching his backpack. Oh, okay. How much of a threat could he have possibly been? Right? So, yeah, the defense case begins to write itself in my head. So, yeah. Basil said, don't do what? Why have they not released the rest of the conversations? Because it's what you want to think. I have no problem believing for even a fraction of a second that what they did release about the conversation is not all the conversation. It is very probable, and it would not surprise me in the least if there's things that would be exonerating to the defendant that were said in that conversation. We're not going to mention that as the prosecutor now, are we? But it's all, of course, Brady material. So Aussie said the parents never saw the gun and bullets or blood in the picture they were shown. The kid scratched it off according to the sheriffs. Yes, but they had a photograph of it, and I'm assuming they were shown the photograph of it. So I think they did see it, but I just as an assumption. And even if they weren't shown it, it's even worse for the government because they didn't have that information. So if you assume they weren't shown the photograph of the picture, that's even worse for the prosecution's case. Because, we didn't have that valuable piece of information. Richard says, thanks for your stream. What should be done to prevent this sort of tragedy, other than encouraging a competent, resolute work ethic? Yeah. In arraignment, the lawyers claimed the gun was locked up. Maybe it was. Maybe it was locked up. So that would, again, go to show lack of negligence. We'll go a long way. Maybe he busted the lock, broke the lock. If we can show forcible entry, or he knew where the key was hidden and somehow got access to it, it helps a long way. 999 from Alec Urban. An ammo search by itself isn't necessarily cause for alarm, but in the context with the other stuff, like the drawings, that raises more red flags than communist China. That's what I'm saying as well too. That's what I say too. Yeah, it sounds like the DA is Kim Fox evil twin. It might well be. It might very well be, my friends. So I'm just going to end the stream for now because that really covers everything I wanted to cover on the stream tonight. Thank you very much for everyone who's here. I hope this education's been helpful. Of course, as things continue to develop in this case, we'll continue to develop them. When we learn more about it, then yeah, as we learn more about this, the analysis might change. But you know, all the things that we learn damning about the parents, there's equal possibility we're going to learn things about the school, especially at that meeting. The exact nature of that meeting is going to be really, really interesting. Really, really interesting. So, you know, the defense definitely has possibilities. The defense definitely has possibilities. Their son, however, is, of course, totally screwed. You know, their son, of course, is totally screwed with the 4 counts of first-degree murder and the terrorism and, you know, the dead bodies and the fact he had the gun and pulled the trigger and all the rest of it. I mean, your best hope is an insanity defense or some sort of diminished capacity defense, which, you know, given the picture, maybe. But you'd have to show he's truly insane rather than just like evil. And there's definitely a difference between those two things. And also, voices in your head is a little atypical for someone of that age. Schizophrenia doesn't normally develop until later in life. But, you know, I'm sure he'll have all the school psychologists in the world now. So, yeah, some sort of, I imagine mental health will come up to it, but I think he's toast. I think the long and short of it, getting to the end of the page, is I think he's toast. So, you know, the defense obviously has a game to play, but, you know, every move ends in checkmate. So it's not going great. There's no death penalty. Also, it doesn't matter. He's under the age of 18, so it couldn't be death penalty anyway. So I didn't even think about death penalty because he's under the age of 18, so it's irrelevant. Yeah, so it's a life sentence is what we're talking about. So yeah, we'll see how it goes. Anyways, I'm going to sign off for now. If you have liked this stream, please remember to hit the like button. The like button helps with the engagement. The YouTubes like it. When you do that thing, it helps with the engagement, it helps the channel grow and all that good stuff. Did you know for a mere 99 cents, you too can become an uncivilian? It's true. If you hit the join button or hit the link that Streamlabs is telling you about from time to time, and apparently Streamlabs has failed, but, you know, normally, then you can too become an uncivilian and help support the channel for a mere 99 cents a month. You get a cool little icon by your name and a little scales of justice by your name, and it's really cool. Also, you can support us at uncivillaw.locals.com or patreon.com/uncivil if you like. And always, please remember to hit the subscribe button and double check that you've done that and they haven't unsubscribed you, and hit the bell and all the YouTubey things. All the YouTubey things that help drive the engagement, man. I hope this has been interesting. We'll definitely see how it develops. We have a lot more to learn before we can get to the end of the page as to the parents' liability. But for the moment, at least, that brings us to the end of the case. I hope you have a good day and good night.